let's start with some RESPA stuff. This had come up with a conversation that I'd had with Jesse not long ago. This is an interesting issue because RESPA, of course, is a statute, a federal statute, but HUD is charged with enforcing it and promulgating a whole bunch of regulations. So our ability to get ensnared in RESPA violations depends in part upon HUD's interpretation of RESPA, even though separately you have courts, of course, interpreting the RESPA statute. So one of RESPA's prohibitions, and it has many of them, we're going to talk about two different RESPA-related issues, but one of them is not allowing for unearned fees, or commonly called junk fees. And where that comes up in our line of work is if you happen to use, and every one of our agents has pretty much unfettered discretion how they wish to do this, but if you happen to charge a brokerage fee that is formulated as X% plus a flat fee of some other amount, you don't want to call the flat fee part anything other than commission. So it's perfectly permissible to say that the commission due on sale shall be, for example, 6% plus $495. What you don't want to say is, under this listing agreement, the commission due is 6% plus an administrative fee or a processing fee, because really it is, or a junk fee of $495. Because under RESPA, it's not a separate and distinct service. Now, there's a technical issue. So this had worked its way through the court. So for a while, until there was actually a Supreme Court decision, and this was just in 2012, until this Supreme Court decision in 2012, there were certain jurisdictions within certain federal appeals court areas where this had been decided, but it didn't apply to everybody in the country. And so now it's gone to the Supreme Court. The Supreme Court has interpreted the statute the way it actually would read, which is that prohibition against the unearned fees really only applies to fees that are split between multiple closing service providers, multiple settlement providers, i.e. that the junk fee prohibition technically can only be enforced if it's money you're splitting with somebody else. Okay, so the good news is the Supreme Court says we can charge junk fees if we want to. The bad news is, number one, it's still tacky, and number two, tacky if it's labeled in a way that does make it sound like it's something that it's not, and number two, you still have some risk that you could find yourself ensnared in a HUD-related enforcement proceeding. And we don't really want to have to litigate it and assert that no, because of the Quicken Loans ruling by the Supreme Court, that no, we're not in violation. So bottom line with that is you can avoid any issue by simply structuring the commission but labeling it all as commission or brokerage fee as being comprised of the percentage plus a flat fee amount if you choose to charge a flat fee amount on top of a percentage. Really, so I'm going to say the opposite of what you asked, which is the prohibition really is don't call what is really part of the commission anything that it is not. So don't call it a processing fee or an administrative fee if really all it is part of the commission. And there are plenty of business justifications why you might want to do that. One of the things it tends to do is, as a percentage, it drives up the percentage on lower end properties. Well, you know, if you take a $50,000 listing at 6%, that additional, you know, $400 or $500 or $600 of flat fee makes a bigger difference on making that economically viable. So there's no issue with price limitations. RESPA does not in any way seek to limit what you can charge. You just want to be careful about the junk fees. And as I said, under this current Supreme Court ruling, you could charge the junk fees, but I would still argue that it's tacky to call something an administrative fee or a processing fee if it's not. Now, the other thing you could do is, if it's a legitimate pass-through, I can't remember if I have that. If it's administrative pass-through, yeah, here's an example. So let's say that you're using a virtual tour provider that charges exactly $395 and you happen to do a pass-through cost. You could call it that if you, just for nomenclature's sake, if you were more comfortable passing that cost along and calling it that separate item, but the safe way to go is just to lump it all together as commission. So again, you have complete discretion as to whether you want to charge a flat fee amount on top of a percentage amount or not, but if you do, call it all commission. Any other questions? Home warranty spiffs. This is another thing that is a compliance issue where the home warranty companies have already worked this out. But in my book, this is more of a tackiness sort of an issue and a lesson on just best practices. So a little history. Home warranties, for as long as I've been in the business, have been in the business of paying spiffs to agents for selling the home warranties. Before a relatively recent RESPA interpretation issue, the home warranty companies would just pay the $50 or $60 spiff to the agents when the agents didn't do anything other than fill out the home warranty application. That is illegal under RESPA because it's a related settlement service provider that's essentially paying a referral fee. So it's kickbacks, referral fees. Now, agent-to-agent referral fees are explicitly accepted within RESPA. So there's a carve-out for that, so that's not an issue. But you can't get kickbacks from lenders, you can't get kickbacks from home warranty companies unless you are providing a bona fide separate service for that. So here's what the home warranty companies have done. In my book, and this is my opinion, the home warranty companies as an industry have come up with a solution that now satisfies the letter of the law while still totally violating the spirit of the law. And what they're doing is they're paying the spiffs still to the agents, but they're purportedly now paying for a separate service. The separate service is, write down the name brand of the furnace here. Does the home warranty company care what the brand of the furnace is? No. Will they issue the warranty if you don't have that information? What won't they do if they don't have that information? They won't pay you the spiff. So in other words, it factors nowhere into their business model. It is just busy work that covers their rear end so they can pay you a commission on hawking their home warranty. The home warranties, therefore, get marked up by the amount of the spiff. I don't know if you've all noticed, but there are a couple of distinctly different practices with home warranties, representatives of which come visit our office pretty regularly. At least one of those major carriers will let you pass along the discount to the customer if you don't take the spiff on it. So I simply want to sensitize you to the issue. We're not prohibiting you from collecting the spiff if you're hawking home warranties, but what I would like to suggest to you is that it's a distasteful practice. It's not why we're in the business. It's not how any of us make our living. Consumers, if they thought that we were paying for our dining out budget by pushing home warranties onto them that we have a financial stake in selling, would probably find that relatively distasteful. If you're on the listing side of a transaction where an offer contains a marked up home warranty, have you seen this? A couple of big teams at other companies will do this. They'll specify the warranty and they'll also specify to be ordered by buyer's agent. Does that sound familiar? I've seen it many times. Have any of you? Yes. I would suggest at that point, if you're on the listing side and you're getting an offer that way, what they're doing is collecting an added commission being paid by your listing client by making your listing client pay a premium for the home warranty that they're requesting, supposedly for the benefit of their client. So just be aware of the issue. Again, you don't have to do anything about it. If you want to fill out the paperwork and note what the name brand of the furnace is and collect the $50 or $60, you're entitled to do so if you wish. It satisfies the letter of the law. But look at it the way a consumer would look at it and think for a moment that this does look a little tacky. And so if you go to the effort on the listing side, when you get offers like what I just showed on that last screen, and you're able to say, Mr. and Mrs. Seller, because every one of your dollars, down to the last one, is important to me, let me explain what's going on. That agent is trying to make an extra $60 on your backside, and so I would like to suggest that we revise this slightly and that instead of a $550 warranty, that the very same coverage be provided for $480. Does that sound okay to you? Just be aware of it. I just think it's one of those things that we're making our living from selling the real estate. I personally find it distasteful if we're less than transparent with clients and there's $50 or $60 or $70 here and there being stuffed into our pockets. Or even more so, if it's being stuffed into pockets, you at least want it to be yours. It's even more distasteful when you're on the seller side. They're being hit up for the warranty and the money's being stuffed into some other agent's pocket. So just be aware of that general issue. This is one where it's more a matter of best practices and avoiding the appearance of tackiness and impropriety, even though the practice, because the home warranty companies have correctly taken it upon themselves to navigate the potentially treacherous waters of RESPA. So you can follow their procedures without any RESPA liability concern. Just be aware of how it looks to consumers, how you can save them money, how you can look like a hero over $70 potentially, and honestly the goodwill can be worth way more than the $70 would be. It'd be very interesting if any of you ever hear later on that a consumer is recommending, that guy went to bat over my last $70. Funny how that sort of little stuff makes a big difference. Any questions on that? Okay. We're just sailing through this. All right, RE/MAX sign compliance, phone numbers. We have a number of non-compliant signs that are out there. Some of those, I think, were probably given a blessing by our firm in error. So obviously, if it was the firm's error in saying signs were okay as ordered, we're not going to make you rip them down. But I want to just remind everybody what those standards are. We've got this thick RE/MAX trademark and graphics usage manual that it is our obligation as a franchisee to comply with. And so all of you have to comply with that, because failure for us to comply could, in extreme cases, mean that we lose our franchise. And then we have people from headquarters that come and forcibly rip the balloon lapel pins off of your clothing, and that can leave some unpleasant tears and snags. So we don't want to have that happen. So quick reminder of the most common compliance issues. It's like the scene in Seinfeld where Jerry goes and delivers the mail for Newman once, because Jerry's trying to get the mail delivered so efficiently that Newman will get a transfer to Hawaii, which Newman's always wanted. Ultimately, the plan backfires because Jerry delivers the mail so efficiently and effectively they knew it couldn't possibly be Newman. And so Newman comes and rips the postal patch dramatically off Jerry's coat. But anyway, I digress. So the blue bar, brokerage information, this comes right out of the trademark usage manual. This bar identifies the RE/MAX office with which the associate or team is affiliated. And then here's the part, as well as the office phone number. The entire local RE/MAX trade name must appear in 2 lines, as well as the office phone number. You can have a cell phone number on your signs, but there's a very specific place where it has to go. If allowed by law, and it is, and in fact I looked in the license law and I actually searched telephone and phone, and there is nothing in our license law in Illinois about the phone restricting what phone number that you use. If allowed by law and approved by the broker owner, an associate may display his or her direct dial telephone number in the blue bar. This is totally fine by us. It has to be a company-owned number, and if you're going to use your direct dial number, technically it has to also be going to a number where somebody can dial 0 to escape and get to an operator. Okay, got that? So you can't have your phone calls from your direct dial forwarded straight to your cell phone and be compliant. So it's perfectly okay if you want to forward your direct dial to your cell phone, but technically that makes this non-compliant, in which case you'd want to use the main office number. And you have to balance this for yourselves. Some of you may decide, I prefer knowing that 24/7 an actual live human being will answer an inquiring call. But anytime a live human being answers the inquiring call, there's always at least some risk, even though we have a very strict policy as a company, and our front desk staff are well trained, and the answering service is actually pretty well trained in all of this. So despite our strict policy, it's always possible that if a consumer calls the main office number, they won't have enough information to be routed to you. So there's always a chance you could lose a lead that would have gotten to you if it was your own phone number, but you balance that against the possibility that somebody will hang up when they get your voicemail during normal business hours because you're not at your desk, and a live answering service, especially if they are able to transfer you to your cell phone, would have gotten you the call. So it's a balancing test. Your call how you wish to do it, but if you put the direct dial on your sign, you need to make sure you're working it through the office voicemail system. As a reminder, this new voice over IP telephone system that we have gives you an awful lot of options. So you can speak with Vicki and she can get you set up to have an outgoing message that has essentially quick dial shortcuts. So you can have your outgoing message and say, I'm sorry I missed your call, please leave me a voicemail message, I'll be notified and will return your call immediately. If you require immediate assistance, dial 0 for the front desk receptionist. Or if you're on a team where you have team staff, or dial 2 to speak with Tracy. Or there's a 90% chance you really don't want to speak with me, dial 2 when in doubt and speak with Tracy. That would be what I would want for the appraisers that call me all the time. I don't know anything about anything, talk to Tracy, and then they call me on the next one. So anyway, questions about that? Stunned silence is the theme of the day. This is what I just talked about. Only off-site numbers are allowed in the white bar can forward to an off-site number. So on the signs, the white bar would be the spot where you could label it as a mobile phone number or label it as cellular, or back in the old days, label it as home. I can think of one agent at a different firm that still does that. So the key takeaways here is the number in the blue bar has to always be one of the numbers owned by the office. If you use your direct dial, you have to have a way for the caller to reach an operator. If you add a mobile number, it can only be done in the white bar in smaller type size. That is to say, it can only be a secondary number. There is actually another way you can do the cell phone number if that's your preference. Do a rider. Because if you follow the design standards and the main number has to be an office number, that forces, if you prefer your cell phone to show up, it forces your cell phone number to be very small. If you do a cell phone rider, then you can have your cell phone much larger that way. So that would be another perfectly compliant way to have a secondary number. But if it's on the main sign panel, the only way it can appear if it's a non-company number is in that smaller secondary slot. And actually, if you're looking at the design standards, if you're flipping through the manual, it shrinks the size of your name. So it clutters up the sign. It's a small enough type size that the cell phone number is not going to be likely to be easily read, and it makes the sign look busier. So if you do want to use a cell phone number, I would encourage you to do that on a separate sign writer. Custom signs. Those are actually much more frequently a problem because of their custom nature. So if you're using Fast Signs or one of the other custom sign providers, because you're doing a really large sign that's going at a commercial development, those frequently result in non-compliant signs at the end of the process. So if you're doing a subdivision sign or a commercial sign or any sort of custom sign of any kind, please run it by us for a couple of reasons. Number one, we need to ensure compliance. And number two, those are going to be expensive signs that are going to be really, really pricey if you have to redo them. Any questions on that? As I didn't bring any examples because it would single out people, there are signs out there right now, and some of these I run past in Mahomet, and I don't have note-taking capabilities usually while I'm running. But we have some examples of really large oversized signs that do not even have our company name on them. Sign placement issues have been stuck in my craw for a period of months. So I'm going to talk about this a little bit because I'm hoping as an office we can actually step up enforcement market-wide and ensure an even playing field, which ultimately benefits our company. Signs are governed by zoning ordinances in every jurisdiction in which we work. And so every municipality is potentially going to be different on sign rules. Most interesting, the village of Mahomet arguably has the most restrictive zoning ordinance. So in Mahomet, it explicitly prohibits the use of, it actually uses the word arrow signs. You cannot have directional signs anywhere in Mahomet, even if they are on private property. So most of us know that it's technically illegal to throw a directional sign in the right-of-way. Most of us identify the right-of-way by the outside, the street side of the sidewalk. Be aware, as our team learned when the city of Champaign came knocking, we had a listing where there was no sidewalk. So it was a good faith guess where the sign could be located. We apparently guessed wrong. The city was nice enough to pull the sign. Now in the city of Champaign, one interesting provision of their zoning ordinance is the city of Champaign says in its ordinance that if the sign identifies a person or a business, that alone then becomes conclusive evidence that that's the person or business that owns the sign, and therefore that's who they'll fine. So you can actually get a fine for that. As a practical matter, none of these municipalities are really quick to do that. More likely what they'll do is every once in a while, usually from a complaint-driven standpoint, they'll go out on an enforcement blitz, yank a bunch of signs, take them to a city facility. I don't know where ours got picked up from, but and then you'll get a little nastygram, but no fine. It's a warning citation, is at least what we got when that happened, on the one where there was no sidewalk, so it wasn't really obvious. Be aware of that. So we know that the right-of-way issue is generally illegal. Don't forget, it's illegal even if you can't see where the right-of-way starts and stops. But going back to Mahomet's ordinance, even if you walk up like a polite realtor, knock on a neighbor's door and explain, I would like to offer you a valuable service. I would like to place a directional sign with my big ugly mug in your yard, because if you let me do that, it is going to make your property values go up because your neighbor's house is going to sell so much faster and because I'm so dang good looking. In Mahomet, even if they say yes, totally illegal. It's explicitly disallowed under Mahomet zoning ordinance. You could potentially do it in some other jurisdictions like in Champaign, but Champaign's ordinance, I think, could still be interpreted not to allow it, because it says you can only display it on the property and only for up to 10 days after closing. So be aware that you want it, for a lot of reasons. We want to, number one, not be tacky. Number two, we want to be compliant with the applicable laws. Number three, we don't want to be a nuisance to other people. So be aware of this, because what are you seeing in terms of the biggest violators? Thoughts? Yeah. So you get a competitor with a much smaller market share that appears to have an institutionalized practice of, why put up 1 yard sign when I can put up a trail of 17? And so there's a trail of 17 yard signs going from 2 miles away in every direction, going out to every main street, and you could, I guess, possibly make an argument, possibly, that those help guide people to the property. Do you think that argument holds any water when it's sold? No, it's just a free, illegal, tacky billboard. When you got a sold sign, full-sized for sale yard sign, located at a major intersection with a sold rider on it, then you're saying, look, if you go in this direction, you can come drive by my property that's not even available for sale. You can't have it even if you want it. It is just to be my illegal billboard. So the problem that I have is, I want us to be compliant with the law. It becomes a slippery slope when we know that most jurisdictions are not strictly enforcing their ordinances. Then somebody pushes that line, crosses it, becomes a slippery slope. They make a regular practice of it. It makes a competitor look like they have far more market share than they actually have. Then our agents and everyone else's agents across the marketplace, in response, tend to want to do the same thing so that they get their free illegal billboards all over the place. And then the result is you pull into various subdivisions and it's an absolute aesthetic mess. Just a forest of ugly signs that, especially with what the snowplows have been doing, is an even worse disaster. So I want to make sure you're all aware of what the actual letter of the various zoning ordinances says. When in doubt, you can always look online for the zoning ordinance, and it's really easy. All the zoning ordinances, if you bother to check, will have a signs section. So you can usually go straight to the chapter on signs and generally keyword search real estate signs, because real estate signs are typically identified with that phrase. One of the things that you'll see, and I don't remember if it was Mahomet or Champaign, I was looking at both zoning ordinances today, but one of them, they will link to a third-party online code service that publishes it, and they warn that the zoning ordinance is subject to frequent change, and it may take a few months before it's updated. So the zoning ordinances are commonly tweaked. I don't know if the diagram that was used is still applicable. It could very well be. It was simply showing you how not to get it in the parkway. Basically, only the city, only the government is allowed to put stuff in the parkway. So I suspect that's what most of it was just a handy guide for being able to identify where the parkway ended, so you were on private property, not public. In Mahomet, it is actually written into the zoning ordinance. In most other jurisdictions, if it's not written into the zoning ordinance, I think it's a well understood informal exception. I am not aware of any instances, at least not in recent years, where local governments have gone yanking signs that had just gone up on a Wednesday for an upcoming Sunday open house. I don't remember ever hearing of it happening. It could very well be it has happened at some point, where once in a blue moon, Champaign decides they're going to go on an enforcement blitz and they yank everyone that they see when they're driving to whatever the site is of the one that somebody complained about. But generally speaking, open house signs are usually going to be allowed some latitude, because that is an example of where the directional signs can be quite important still. You still, in a perfect world, want to place it on private property, not in the right-of-way, knock on the neighbor's door, and whether it's in the right-of-way or on the neighbor's lawn, you'll probably still score a lot of goodwill points if you knock and ask permission, as opposed to neighbor getting up on some morning and seeing your mug staring back at them. I mean, depending on how good looking you are, it may be fine, but it can be a concern for some. And before we start trying to work with the local governments to step up enforcement, it would be highly preferable if we were not big-time offenders. Sort of a clean hands issue. Any other questions on that? Any other thoughts on that? All right, so social media. I've talked a little bit about this in the past, but we had an interesting sort of flaming example of bad judgment lately, not within our firm. So the Illinois Real Estate License Act requires that you honor its provisions with any advertising. So the trick with social media is, obviously, if you're doing social media via a business page, the whole page is business oriented and is going to presumably have your business contact information, is going to be license law compliant, insofar as we assume that you're all at least putting the brokerage name and the state in which you're licensed and all the stuff that's required under the license law. The more common gray area is many of us use social media first and foremost for social purposes. So any of you who follow my social media antics will see that easily 90% plus is going to be truly personal. My life is a ridiculous open book, but it's going to be 90+% personal with very occasional real estate stuff in it. My business page is almost exclusively real estate, and every once in a while I may deliberately, for business purposes, post something personal just to give the people that like the page, who are not the same as my friends, some insight, for better or for worse, into my personal life. But anyway, if you do something on social media, like instead of sharing a photograph of your breakfast, which I don't encourage anyone ever to do, but instead of that sort of common social media post, if you say, hey, come visit my open house, or hey, I've got this great new listing, or hey, there's this great free money grant program available, if you do anything that crosses the line into I'm wearing my real estate licensee hat, there's a very good chance that those actions could be interpreted as advertising, and if it's interpreted as being advertising, all the requirements of the Act attached to it. The Illinois Real Estate License Act, as currently written, does not have any explicit exception for the fact that some social media platforms would make it literally impossible to comply even if you wanted to. RE/MAX Realty Associates plus phone number would consume all of the characters permitted in a tweet, for example. That wouldn't leave you a lot of room for content. So we urge that you have a common sense sort of a approach to this. So I said a reasonable test. Again, if the IDFPR was out enforcing, there is no exception that they're required to give you on this, but if you're reasonable, they're looking at it from the standpoint is a consumer being misled? Are you hiding the ball in terms of your business information? So as an example, if you're talking Twitter specifically, where you know you have a very small character count, our readers no more than one click away from being able to see that you're a licensee, with what firm your license is affiliated and the firm's contact information. So for example, if you ever post real estate related stuff on Twitter, make sure your Twitter profile has all of that stuff. Same thing on Facebook. If you're going to be if you're going to have a purely personal profile on Facebook, you really need to not use your personal profile to post business stuff. Conversely, if you are going to post some business related stuff on Facebook, which is fine, if you are going to do that, make sure that when people click your profile, they see, aha, yes, that person is a realtor, their license is at RE/MAX Realty Associates, they're licensed in the state of Illinois, and that's the business's phone number. Questions about that? So just thinking out loud through the marketing strategy, I do some of that just because if it's of general interest. So I'll post real estate specific stuff usually, or local economy stuff specifically on my business page. But there are sometimes real estate related articles that I'll post on my personal. I do make a conscious decision which goes where, and sometimes it'll go both places. If it goes both places, it goes to the business page and I will share it from there. Do you know why that makes sense to do?
Maybe you'll get more people to like your business
That's one, but what can you do from a business page administration standpoint you can't do from a personal? You can see how many people have viewed it. Yeah. So you want to be careful about, I'm going to share this on my business page, I'm going to go separately post the same thing directly on my personal. All right? So be deliberate about how you do it. Share it to your business page, post it to your business page, then from the post there, click share and share to your profile. Then the cumulative views will be reflected on that business page posting. Ultimately, the license law and the code of ethics generally are enforced on the basis of, would a reasonable consumer be misled or confused because of lack of clarity? So definitely don't play hide the ball, but please always, always be sensitive to, if I were a run-of-the-mill consumer and I didn't know anything about the industry, would this confuse me? Would I be unclear? So going back to Jesse's question, I don't have an issue if you're posting articles and just posting a link to it and it's not propaganda. It's not RE/MAX propaganda. It's not propaganda for some program, some seminar, something you're doing. I don't think there's any issue there whatsoever. And quite frankly, I don't necessarily think you would necessarily in your post on any true business post have to then say, asterisk, this person is an active real estate broker in the state of Illinois with RE/MAX Realty Associates, main phone number, such and such. But make sure all that stuff's in your profile. Keep in mind, Facebook, if you don't allow it to be shown, Facebook will mask things like your email address. Do you all realize that? So if you go looking at other people's, if you start looking at a few of your friends and you go to the About page for them, you'll see many of them have an email address that's at facebook.com, and that's just a mask that forwards through to whatever email they've provided. Well, you'll probably, if you're using a branded email of some sort, you're going to want to make sure that actually shows through. And you will not want to, and you'll see on some About, email for so-and-so's phone number, email for so-and-so's contact information. Make sure if you're ever doing anything real estate related that your About and your profile is sufficiently transparent. People can figure that out. So make it as easy and straightforward as you possibly can. All right? So here's one that probably seemed obvious to most of you, but I'm going to show you why it's not. Don't steal other people's stuff. So here's some considerations. You can always share a URL for a customer format display if it is your own listing. But keep in mind that customer format display, if you can do the direct email to client. I never do that because then I don't know if it got to the client. I don't know if a typo meant it didn't get to the client. So I'll always do from my email so it generates a URL. Then I see the URL, and as you may know, those URLs stay valid for like 2 weeks or so, and then they expire. So it's a new URL that's generated on the fly every time you email those listings. Those customer display listings, because they are at their own URL, are not just privately messaged to somebody. They are publicly posted on the internet where they can be accessed by anybody. But those are not intended for public posting. They're intended to be shared with the public, but they're really intended for you to share with your client individually. And they're going to have your smiling mug on them and your name, and none of that other information that would normally be required if it was being advertised. If you are sharing a listing that is not your own, such as if you chose to promote an entire neighborhood, which is what the example I showed you was doing. So the idea is not fundamentally a bad one. Hey, I'm going to do a featured neighborhood of the week, and I'm going to showcase all the listings that are on the market there. There are perfectly permissible ways that you can do that. You can share a link to an IDX compliant site. Do you know what IDX is? Anyone? What does it stand for? Oh, see, aren't you glad you're here? This is what gets the butts in the seats. Internet Data Exchange, that's the nugget that you came for. The Internet Data Exchange, which is a universal data sharing platform that is used for MLSs to propagate data out to a variety of other sites. And ultimately, the purpose, much like the MLS itself, is that everyone has to play by a uniform set of rules. And so an IDX feed, which is what allows Realtor.com, RE/MAX.com, your individual website at RE/MAX.com, to have full MLS search capabilities. That's all made possible via an IDX feed. Think about what's different from that customer format display versus what you would see if you went and searched listings at your own website and then your search included listings that weren't your own. What's different? I'll give you a hint. It would start with something like listing provided courtesy of. And that's where you get the compliance factor. That is the key difference. It doesn't show that on the Innovia customer display when you generate a URL. Now, you could do a geo-mapped, you could do a map search on Realtor.com, a mapped search on your own Remax IDX capable website, post a link to that, and that would, you could post that on Facebook and somebody could then see initially come to a screen with all the push pins showing all the houses on the market in the MLS in that neighborhood you were choosing to promote. But at least there, if you're linking to an IDX compliant site, you're going to have that disclaimer of this listing provided courtesy of so-and-so. If you're linking to something IDX compliant, you are generally going to be okay if you're getting into showcasing other people's listings, because after all, that is the whole point of your IDX compliant site. It's one of those, every one of us has the ability to opt our listings out of IDX. I don't know if you've noticed that. It's one of 4 million fields that you would typically never touch when you broker load a listing into the MLS. There is an IDX opt-out option that you could say, I want to opt out. Now, the reason is, if I opt out from my listing, that means that there is no chance that my listing is showing up on some competing brokerage's website. But why is the default setting to opt in? Everybody benefits from the exposure throughout the entire marketplace, and in fact, many of us would specifically use in a listing presentation the fact that when you list with me, not only will your listing be promoted on Remax.com, but your listing will be showing up when people go do their searches on ColdwellBanker.com or on Century21.com. So the IDX is one of those things where, generally speaking, there's a understanding it benefits everybody. You can opt out if you decide you don't want to. If you're linking to something that is IDX compliant, you are almost certainly on safe ground. The agent in question there used a method to accomplish what he wanted that just happened not to be compliant when he probably could have done substantially the same thing, accomplished the same marketing purpose, and done it in a compliant way. So again, it's a good example because it was an easy misstep that wasn't malicious, and I want you all to be aware of it because I also don't want anyone to think, hey, that's a great idea, and then suddenly we have 10 people doing the same thing, or 450. Buyer agency agreements. It's the last item I'll talk about just briefly. And buyer agency agreements are not mandatory, for one thing. That's a starting premise. I've personally never, ever used one in my entire career. So there are downsides to not using them. It can involve some increased risk, but it's certainly not mandated by statute. What is mandated by statute is written notice of buyer's designated agent. Everyone familiar with and have access to that form. So just as a refresher, in case you don't want to raise your hand and say, no, I'm non-compliant, would you like to record my name for the record? A buyer agency agreement, if it is done by, for example, the Illinois Association of Realtors, is going to be Illinois Real Estate License Act compliant. It's going to satisfy the requirement to officially notify that consumer that you are their designated agent acting on their behalf. If you choose not to use a buyer agency agreement, you at a minimum under the current license law have an obligation to provide a written notice of buyer's designated agency and to keep a copy in the office. That doesn't even have to be signed by the consumer. There's a blank for you to sign it. And I did create a form a couple of years back that we have on file here in the office that does just that. So if you prefer not to use a buyer agency agreement, we still need to make sure that at the time that you undertake the first activity where you're acting as a designated agent, that you're giving them that form. And you can then explain, part of why I created that form is you don't have to hand them a contract and say sign here. You just say, hey, this is required under the license law to let you know in writing that by showing you this house, it creates no obligation on your part, creates a ton of obligation for me, but none on your part, but the license law requires that I notify you in writing that I am your agent, designated agent under the License Act, and I now am acting on your behalf at this point. Keep in mind that in a typical scenario, that would be sign call on your listing. Are you the buyer's designated agent when you show up for the sign call if it's your listing? Not at that point. You're the listing agent showing up to show your listing to a consumer, not a client. You're showing your listing. That person points down the block and says, hey, what can you tell me about that one down the street listed by some other agent? I can tell you, and you look it up on wireless.illinihomes.com on your smartphone, pull up the details, see that it's vacant, go show. You tell the client about it, would you like to go see it now? Absolutely. At that moment, you've switched hats from showing a consumer a home as the listing agent to, at that moment, undertaking an activity that under the License Act makes you that consumer's designated agent when you cross the street to go see the other house. So technically, under the License Act, when you're required to provide that disclosure at the earliest moment that you undertake an activity on their behalf, you are theoretically supposed to sign that right on the trunk of your car. So we have that form if you choose not to use buyer agency agreements here locally. If you choose to use buyer agency agreements, they're a great loyalty tool, but I encourage you to look at them as a tool only. Because even if you choose to use the relatively ironclad version that is exclusive and has written into it a right of compensation, even if you have that, realistically, if the buyer were to ditch you even after that, does it necessarily mean that it's always the best idea to go sue their pants off? Probably not. And we have to talk agents off that ledge periodically, because there's always a desire, especially once you've just been hosed by a client, there's always a part of you that's going to want to say, I don't care what it costs, I want to go after them. And that's rarely the best thing. So I want to focus on the preventative effect of using these agreements. They're going to be you're going to tend to want to use them to reinforce client loyalty and to use them for talking points, not because you literally can be expected necessarily to successfully enforce them in court. Although the ones provided by the Illinois Association of Realtors probably are perfectly legally sound for that purpose. Still not a course of action I would advise, and not a course of action I would personally undertake even if I got hosed by a client. I was talking to Brandon Moore last week. He and I rode up together, back together from St. Louis from the regional awards. And it was interesting because it becomes easier and easier in this business to get over the client that wastes a whole bunch of your time and then basically screws you over. It's very hard to get past that because in this business, most of us are in it because we connect well with people, and so it's very hard not to take things personally. It's easier to get over it when you know that the next transaction is right around the corner. If you're not to the point in your business where you always feel like the next transaction is right around the corner, it's much harder to get over it. And as an example that I had shared with Brandon, I remember, and it's been a decade at least, but I had deliberately not gone to extended family Memorial Day weekend plans with my wife. We would have gone out of town and seen family, but I had out-of-town buyers. Showed them houses all weekend long, showed them everything that met the criteria that they specified, and on Monday at the end of the holiday weekend, some friend of a friend say, hey, did you look at this house? Totally wasn't what they had specified. It was tens of thousands of dollars outside the price range, clearly outside any parameters that I had ever been given. Called the listing agent, looked at it, bought it with the listing agent on the spot. And so 12 years later, those people are still the people that screwed me out of my family Memorial Day weekend. So I mean, it's evidence that you don't ever fully get over stuff like that. So when I say, just get on with the next transaction, I don't want to give you the impression that I necessarily forgive and forget real easily, but you still need to do that. So look at the buyer agency agreements as a tool for trying to minimize the chances that will happen as you're talking through some of those provisions. Even if you just talk through the provisions and say, and I'm not going to have you sign this, I just want you to understand how my job works. I am going to devote a lot of time and a lot of effort to you. I have zero guarantee that I'm ever going to get paid for it, but by golly, if you buy a house, I would certainly hope that at that point I will have completed my job and will get paid. And let me explain to you the common ways you could end up doing that and not getting me paid and how we can avoid that. Where you can find those, and I'm going to show you quickly here. If you go into the IllinoisRealtor.org site, so the Illinois Association of Realtors website, IllinoisRealtor.org, if you've never done this, you'll have to create a login. So if you've never done it, shame on you. But you can create a login. You'll probably have to have your NERDS number, which you can find on your Realtor magazine. But from the IAR website, it is kind of hidden. So that's what it looks like. You've got to go down to here, free downloads. Okay? And from there, you can find all of these forms. IAR is extremely useful because remember, as divergent as the different parts of our state are, everything here, of course, is crafted to be compliant with the Illinois Real Estate License Act. So the IAR website is going to be very important for stuff like this. Notice that these are alphabetized, which puts buyer agency agreements away from each other because there is an exclusive with and without dual agency, and then there is a non-exclusive. What's the biggest reason people don't confront their new buyer clients with a buyer agency agreement and say, sign here? It's kind of like saying, we're here at a speed dating event, and I'd like to get hitched right here on the spot. Sound good to you? It's kind of a tough sale to close at that juncture. And so part of why I've never gotten in the habit of using the buyer agency agreements is I've never developed a point at which I'm comfortable balancing, is it too soon? Am I level jumping in our relationship? Will you sign here? Versus, well, then you wait a few more outings. They've driven around in your car for hours and hours. You've developed a rapport with them, and then it's a little tacky. What I'd really like for you to do, now that we know each other, is I'd really like for you to sign the prenup now that we're already married. So, or at least living in sin at that point. So anyway, when you look at this, those are the real world challenges that you face. So you may, because of that, choose to use a non-exclusive that says, this will not bind you exclusively to me. We agree, we can still see other people. It's non-exclusive. And then there is the exclusive. The most ironclad one is going to be this exclusive buyer agency or buyer representation agreement with dual agency. Look through this and see that it includes compensation. Okay? So if you want something that is as close to ironclad as you can get, this is the form that you want to use. If you want to study these at your leisure and then chat with me about what your priorities are and what you think is the best fit, please feel free to do so, but I want to make sure you know where those forms are. Nick has told me stories of other people who have just ripped into clients when they found out the client had used some other agent. Now let's step back for just a moment. I understand that it's hard not to take it personally. I'm guilty of taking it personally. I get it. I empathize. However, let's just objectively analyze that situation. Does ripping your former client a new one in any way further your business interests? What will it solidify in that client's mind about that client's ultimate choice of realtor? Man, I ditched that idiot just in time because he is a jerk. On the other hand, if you didn't do anything wrong, and I eventually got to the point where I would kick myself thinking, whatever it was, if I knew I didn't do anything wrong by the client and I got along okay, it usually is I'm simply guilty of failing to maintain top-of-mind awareness. And once you get busy, it's very easy to do. You've got the stuff that's on the burners right now that's ready to go, so the stuff that's not ready to go, unless you are meticulous about CRM usage and a drip campaign, which Jeffrey's and our team in general, but Jeffrey specifically, is meticulously implementing, and so far with some pretty good results. You're guilty of just not maintaining top-of-mind awareness. So if that happens, it's shame on me, not shame on them. I may think, all right, well, so they settled for some vastly inferior competitor. That's their loss. But if you do what Jesse did, his example is a really interesting one, which because you actually crossed paths with them. You were eyeball to eyeball in the office briefly? Yeah. Yeah. So when that happens and you do what Jesse did, it's really quite ingenious because he did the nice guy thing. Through gritted teeth, he pounded out the email that he is so stinking happy for them in their home purchase. But what's more likely to happen at that point? They're probably, assuming he didn't do anything to make them mad, they're probably going to feel kind of guilty, and there's a really good chance that the person that sold them the house isn't the one they'll refer, because especially if they're Catholic, they'll be so driven by guilt, they'll think Jesse's the guy that they have to send all their friends to. That sort of thing does happen. So be mindful of the fact that it's tacky and wrong to chew out the past client, but it also is contrary to your own business interests. So I'm actually really glad you mentioned that because it is very hard to do, but going way out of your way to be the super nice guy. Because if Jesse did absolutely nothing, sent nothing as a follow-up, what he chose to do is actually better because the client might feel a little awkward. Oh man, I crossed paths, now I'm feeling guilty. But suddenly they feel pretty good about it and they think, man, he's such a good guy. Kind of makes me sorry that we did that to him, and the only way to assuage my guilt is to send all of my friends to him.
That happened to me. I was working with a client who I and they bought a house that I was showing to them and with somebody else. They came back to me last year, sold a rental house with me, and referred me to someone. So, and I never, went back and to them and said, why did you use that other person? I just congratulated them, and they came back to me, and they may buy more properties with me.
And I've had the people that have been, almost as explicit as, oh, what a fool I have been. Please accept my sincerest apologies. We strayed off the path of rightness with Matt. And it was a terrible mistake, and we never intend to do it again. So, but you won't get that if you do a scorched earth thing.
Yeah.
So just keep in mind the business practice. I'll hang around if you have any other questions, but you have something, Nick?
Just a comment. One thing that works better than here's how I get paid is here's how I get compensated.
Sure.
So if you use that word, and also everything I do between now and when we find a house and close it is all grass.
The other thing on that subject of the distinction between paid and compensated, I would even take it one step further and just call it revenue, because compensated suggests that it is all compensation. It is not. If you say instead, I am an independent, self-employed business owner, and the only way I generate revenue is upon a successful closing. And keep in mind, revenue is not my total profit, because I have all these business expenses, all the miles that go on the car in the process. All right, thanks, guys.